May I please, Your Lordship? I beg to mention item number 4, Lordship. Matter has become infractuous as petitioner expired, Lordship. He has challenged the order of a legal authority service regarding a dispute between he was a member of a board of development committee of a masjid committee, Lordship.
Take down number 4, Mr. ABT
ABT
Hawk, learned counsel appearing for the writ petitioner. In this case submits that in this proceeding, the petitioner was seeking enforcement of his personal right, but during the pendency of the writ petition, the petitioner has expired, as a result of which the writ petition has become infructuous. As such, the learned counsel for the petitioner prays for closing this matter as infructuous. Prayer allowed. On the request of learned counsel for the writ petitioner, this matter stands disposed of as infructuous.
Lordship, may I please for listing of a motion matter tomorrow, Your Lordship, it relates to an eviction process, Your Lordship. We have put to challenge an eviction notice, Your Lordship.
Yes.
It is a lordship. On IA, I have filed in a WPC where the interim order granted by this honorable court was actually vacated for non-appearance of the concerned advocate. And they did not file any proper application for withdrawal, and party was not informed actually. It is a bona fide need on the part of the petitioner until disposal of the writ petition that order to be continued. So
No, we'll entertain your prayer only when a complaint is lodged. Because if what you are saying is correct, then this is a misconduct on the part of the lawyer.
yes, I am the newly engaged advocate.
All right, but the other advocate, whoever has done it,
Yes,
it is a misconduct.
yes.
So what has been done?
Then, yeah, your lordship is right. Then IA lordship,
IA will not list it unless your client takes action. How do we know which is the truth?
because the application which is filed in the record of the WPC, which I have seen in the record room, copy two has been written to the concerned petitioner, but he did not get any copy.
All right, but no notice will be issued in your IA unless the client takes it to its logical conclusion.
I
That
need to
much-
file a complaint. Much obliged.
Yes.
May I please, Your Lordship? I beg to mention an item for listing. Lordship had passed an order regarding the convening of a no confidence motion for the fixed matter on 27th of September, but the item was listed before a wrong bench. So can
Why
it be-
wrong bench?
before another bench? So can it be listed on Monday?
No, if it was listed before another bench, then what is the problem? That bench will take up the matter
No, they said they will not be able to take up the matter. It's a bench 5 matter.
Monday.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 6, Lordship. That matter has become infructuous, Lordship.
Item 6.
6.
Mr. A. Mohammed, learned counsel for the writ petition, submits that due to long lapse of time, the writ petition has become infructuous and therefore the same be closed. Taking note of the submission of Mr. Ahmed, this writ petition stands closed.
But I am on behalf of the respondent number 5.
You're right. Mr. R. Islam, learned counsel, is present on behalf of the respondent number 5.
5.
Taking note of submissions also is closed. And Mr. N. Goswami, learned G. Assam for respondent numbers 2, 3, and 4. So put it in serial order.
May I please, Your Lordship? I beg to mention item number 5, Your Lordship, with the consent of the opposite counsel, Your Lordship. Due to personal difficulty, there are 2 reasons, Your Lordship.
You wait, we'll see what is the matter. Top of the list, no adjournment.
Pardon, Your Lordship.
Top of the list matters, there will be no adjournment.
Okay.
Daily list for admission, item 1.
May it please, Your Lordship. This matter relates to claim for an educational loan by a student, Your Lordship, who belongs to a very poor family, Your Lordship. And I have filed an additional affidavit to bring on record that educational loan has been granted to the students pursuing the similar course from other bank. If Your Lordship takes up the additional affidavit, starts from page number
Yes. You have received copy, Mr. Ganguly? Any instruction required on this?
So as far as my instruction is concerned, there are admittedly the SBI and the Canara Bank have given notes, but the fact remains that every bank doesn't have the same guidelines. Our guidelines are somewhat different from the others. I've also examined matters in other states also. Sometimes what happens is that every bank modifies the guidelines as per its own norm. Now we have taken a certain view, Manoj, in this matter, that either he has to come in through a common entrance test, or he has to the selection has to be based on the last marks in the last qualifying examination. In this case, this would be the higher secondary examination. A or B. Now, A, he doesn't come under B, that is not claiming. But if he comes under A, then he has to come through a common entrance examination. And a common entrance examination, as we understand, because there are also other RBI circulars, I'm not relying on these in this case. Common entrance examination means, those examinations which are conducted by the government itself, government in the sense that large scale examinations like NEET or CAT, those type of examinations. This is a local examination. We cannot give in the case
So
of
why is that? What is the rationale?
the rationale is that an exam like the NEET or the CAT or the nowadays we have for university the CUET those have a certain standard which are set at a pan India level or even at a pan state level. Here we have an examination where there's an institute that has held an selection process through some test.
But these loans are those not secured?
No, this will be unsecured. This will be unsecured. Above 7.5, it has to be secured. That is why he has come, because he wants the.
So why don't you apply before the SBI?
Lordship, that can be done, but as what is he is submitting a loan that is not supported by the.
No, you see, you can't. The court cannot force a bank to give you loan.
Correct, Your Lordship.
The court can only see whether the bank has adopted a discriminatory approach or not. So if SBI has given a loan to another candidate, you go to SBI. If they don't consider your prayer, then we can intervene. But
if I may just point out one thing, Manoj, last time your lordship had suggested the same thing. My learned friend said that it has to be the nearest branch. Same situation arose before the Kerala High Court, Manoj, in one matter where he did not approach the nearest bank, Manoj, and the matter reached the High Court. The High Court said that this type of discrimination is not allowed. He can go to any bank, Manoj, which gives him a loan. There's no difficulty in that. So he can still approach SBI also.
No, had the lordship informed me at that very point of time, I have approached your lordship in 2022, your lordship. Now I am about to going to complete the course, your lordship. Now lordship will kindly see the documents that he is relying on at page 36 of the affidavit.
Mr. Laskar, what I'm saying is there can be no mandamus to issue loan to you. You can argue the matter for whole day because we are on legal principles.
Lordship.
We are not on convenience.
Lordship.
We are not on who wants what, who
Lordship.
doesn't want. That doesn't matter to us. We'll only see the right, if any, which is violated and under what principle of law it can be protected. So you have to argue on the principle, not what your client wants. The principle, one of the principles can be discrimination. Discrimination, you have to make out a case. Another bank is giving loan, so this bank should give. It's not a case of discrimination. Discrimination will be if the same bank chooses to deal with your client differently. So it is a matter of legal advice. You have to give your client what is to be done. Otherwise, we'll pass our judgment in accordance with the law. How can we compel a bank to, extend loan to you, unsecured loan, if they feel that it is not a good deal?
Lordship, this is not a general loan for.
All right,
for,
you are.
Yes, lordship. I just want to show that they are saying that it is not supported by their schemes or by their guidelines, your lordship, which is at page number 36 of the affidavit in opposition.
Yes.
I'm not on discrimination, but my submission is that I'm covered by this, your lordship. And this educational loan is in accordance with the model loan that has been approved by the Reserve Bank of India, your lordship. I have also brought the recent.
First, you place the case, please, from the beginning.
Lordship.
Who is the petitioner? What is the matter?
Yes. Now, this petitioner, your lordship, he belongs from MOBC category and a tea garden laborer, son of a tea garden laborer, your lordship. Now, after completing his higher secondary course, your lordship, class 12 in science, he participated in an examination process conducted by the Shifa Pharmacist Institute, which is approved by the National Pharmacy Council of India, the highest body, your lordship, and it is also approved by the Srimanta Shankardev University of Health Sciences. Now, these are the courses where there is no combined interests, like for NEET, it is for all over India or for all over Assam. But these are the tests for D-Pharma, Diploma in Pharmacy. These are conducted by the institute itself. The institute called for an advertisement. He applied and he participated in the selection process. And he came out successful in the selection process. I have given at page number 17, annexure 3. Now they have, this is the selection list that was published, and thereafter, your lordship, as per the course structure, your lordship, he is required, for the whole course, he is required an amount of rupees 2,84,000. Page 18, I have given the course structure of the institute. Now, his father is a tea garden laborer, your lordship. He somehow could manage 50,000 rupees, and they have taken an admission. And thereafter, he approached the bank. The bank said that, yes, you can apply. Accordingly, he had applied. He was waiting for the loan. Every time he goes, they said that, no, you have to give a collateral security. What is not prescribed in the education loan scheme? Up to rupees 7.5 lakhs, there is no question of giving any collateral security. And these are tea garden laborers, they cannot give. But they have not given any reason for rejection, stating him any ground. Actually, under this model education loan scheme, they are to, within 15 days, they have to inform him that you are not eligible for this reason. But they have not given it. So he was approaching, they said that, okay, wait, and ultimately he had to come before this honorable court, your lordship. Now, this institute is also approved by the Pharmacy Council of India at page number 19 I have given. Because this is one of the requirements that the institute must be recognized by the competent authority. So this institute also covers under this scheme, your lordship. Then at annexure 6, page number 20, I have applied for the loan on 6th April 2022.
Page number
20. This is loan application which has to be done online, your lordship, on 6th April 2022. And he has claimed for a loan amount of rupees 2,84,000, which your lordship will got at page number 21. It only covers the course fee and the hostel fees, nothing else, your lordship. At page 21, you have to give the details, how much amount for what purpose you require. So at page 21, loan required is 2,84,000. Thereafter, your lordship, I have annexed the PNB Saraswati loan scheme that is available in the website. This is an education loan scheme which is framed in accordance with the model scheme that is being circulated by the Indian Bank Associations and approved by the Reserve Bank of India. So as per this scheme, your lordship, the petitioner is entitled. If your lordship sees, margin up to 4 lakhs nil, the eligible person should be an Indian national. This is one of the criteria. Lordship has got it, the eligible person. In column number, row number 1, 2, 3, 4, 5, 6. He must be an Indian citizen, national. And number 2, he should have secured admission to professional technical course in India or abroad through entrance test / merit-based selection
you are
process.
reading from page 22.
22.
Where is it? Which part is it?
Lordship will get it. First, it is in loan amount, then interest rate, margin up to 4 lakhs. There is no margin, nothing is required, your lordship. Repayment period is up to 180 months. Lordship has got it.
Yes.
Then repayment holiday 1 year after completion of studies. Then processing fee nil, no processing fees required. Who is eligible under this scheme? Number 1, he should be an Indian national. And number 2, he should have secured admission to professional technical courses in India or abroad through entrance test or a merit-based selection process. Now, what my friend is submitting time and again that I have not been enrolled through an entrance test. But there are 2 options, your lordship. One is there must be an entrance test or there must be some sort of merit-based selection process, which my friend is not arguing. Or so accordingly, your lordship, on their advice, I have applied. They said that yes, you apply. Thereafter, I kept on going to bank. They said that yes, it will be given, you will get it. But ultimately, they did not give me anything in writing. They must give, as per the scheme, they must, within 15 days, they must inform me that no, you are not eligible. Then I could go for some other aspects also. But that has not been done. Under these circumstances, what was they saying? They said that you have to give a collateral security. His father does not have any landed property, and that is not also requirement under the model education loan scheme. Up to rupees 7 lakh, it is in their scheme. They have enacted, your lordship, in the affidavit in apposition at page number 33. Affidavit in opposition, their ground is that I am not covered under this scheme. And my case is that I am covered under this scheme. Page 36. Page 36, your lordship has got it. this education loan scheme, PNB Society aims at providing financial support to meritorious students. This is the only criteria, Your Lordship. They have to find out whether he is a meritorious student or not. This is the only criteria for granting of an education loan, Your Lordship. For pursuing higher education in India, the main emphasis is that a meritorious student, though poor, is provided with an opportunity to pursue education with the financial support from the banking system with affordable terms and conditions. Now, eligibility criteria, Your Lordship, should be a resident Indian. And number two, should have secured admission to a higher education course in recognized institution in India through entrance test or a merit-based selection process after completion of HSC, that is 10+2 or equivalent. So this is the criteria, Your Lordship, either through an entrance test or through some merit-based selection process. And then Your Lordship will come to clause number C, which my friend is relying. Where the student has obtained admission in eligible course through merit-based selection process, he or she could be considered meritorious. So if he gets an admission through a merit-based selection process, he or she could be considered meritorious. And the second part says, generally admission to professional and technical course is through common entrance test, and those who got admission through this process be considered meritorious. So meritorious, two definitions are given, Your Lordship. The first part says that if a student gets admission to an eligible course through a merit-based selection process, he could be considered meritorious. And in case of admission to professional and technical courses, it is said that generally a common entrance test is held. And if a student is selected through common entrance test, he or she could also be considered as meritorious. Now, my lord, my case is that I have got admission to this institute through a merit-based selection process. This case is that there is no common entrance test. If for this type of courses, there is no common entrance test, either in Pan India level or state level. Every institute conduct its own entrance test. And thereafter, I have got selection, Your Lordship. Therefore, the amount of they are saying is that I have not got through a common entrance test. That is not agreeable, because for merit, there are two considerations given. First is that where the student has obtained admission in eligible course through merit-based selection process, he or she could be considered meritorious. And secondly, generally, admission to professional and technical courses is through common entrance test, and those who get admission through this process be considered meritorious. They are glitching on this thing, that there is no common entrance test. Now, the only thing that is required under education loan scheme is whether he is a meritorious, and the definition of meritorious is provided that he should either get admission through a merit-based selection process, or it should be a common entrance test. I have then filed an additional affidavit in reply, where I have said that he has already passed the first year exam also, Your Lordship. If he is not meritorious, the page number, the additional affidavit starts from page 45. And at page 51, I have given his first year exam result, Your Lordship. He has already completed the course, and these courses have very good tendency of getting employment, because pharmacy course, diploma in pharmacy. He has got 585 out of 1,000. That is almost, he has got 58.5% marks, Your Lordship.
Which page? Where is
Page
it?
number 51. See,
This is not legible.
then Lordship will get it page number 49. I have given the type copy also. He has cleared the exam, Your Lordship, first year exam. Whether he is meritorious or not, whether there is any chance of his employability or not, that is the only thing that is to be considered, Your Lordship. And then I have also annexed the letter which is issued by the institute, giving him a shock cause that if he does not pay the fees, Your Lordship, he will be thrown out, Your Lordship. By saying that the case is pending, Your Lordship, he is somehow continuing his course. And then I have also filed the additional affidavit showing that other public sector banks, like that of the petitioner, Your Lordship, they have given the and this is the recent model education loan scheme. Lordship will kindly peruse for a moment, because this model education loan scheme keeps on modifying by the Indian Bank Association with the permission of the Reserve Bank of India, and they have to follow this model education loan scheme, Your Lordship. This is the latest one on 2022. If Your Lordship sees the first page, Lordship will see that the amendments to this scheme are approved by the IBA Managing Committee. At the bottom, it is given that this scheme is approved by the IBA Managing Committee at its meeting held on so on. The Reserve Bank of India has also approved it, and the Department of Financial Services also. And this also clearly says, Your Lordship, who is a meritorious at 4.3. Because the only consideration for granting of an education loan is that a meritorious student should not be denied of studying because of financial constraints. And up to rupees 7.5 lakhs, he is entitled to get the loan without giving any sort of security. They are also the same criteria that is being stated by the bank. And Lordship,
What is the selection process here?
They have done it, they have taken one interview and they have also relied on the marks scored in the last higher secondary exam. Both have been combined. One from the interview they have given and one from the last qualifying marks. Then both of them added and they have been selected, your lordship. So this is a merit-based selection process. That is my case, and it is not their case that it is not a merit-based selection process. And this model education loan scheme at page number, lordship will kindly see at page number 7 for a moment that I have given. The model education loan scheme at page 7, clause number 11. Clause 11. Lordship has got it. So as per clause 11B, they have to intimate within 15 days. Whether if he is not entitled, they could have intimated him that you are not entitled. He could have availed the other options. And at clause D, your lordship will see that in case of rejection, your lordship, they have to take concurrence from the higher authority, and the reason should be informed to the petitioner. That has not been done, and because of which I was compelled to approach this honorable court, your lordship. B and D, lordship will kindly see clause number D, that in case of rejection also, they have to take the concurrence from the higher authority, and the same should be communicated to the
So
petitioner.
this is the 2022 model.
22.
What is the rule which was applicable in your case?
This 2022, your lordship.
2022.
I have applied in 2022. And then also in
So there was no formal communication.
no formal communication. That is they are only saying was that they asked me to give collateral security, which I could not. And even in their affidavit in opposition, they said that if I give collateral security, they will grant me the loan. This in their affidavit in opposition, they are stating me that if you grant collateral security, I could have given, had I have any landed property, I have given.
Where is that statement?
Lordship will got at the affidavit in opposition at page number 31. Paragraph number 6. That in reply to paragraph 10 of the writ petition, the answering respondent denies that the action of the bank violates any right of the petitioner, much less the rights under Article 14 and 21 of the Constitution. India. It is submitted that the petitioner is not eligible under the PNB Saroswati scheme. However, he is free to obtain education loan if there is sufficient security offered as collateral for the loan amount, which is not the requirement under the model education, under the education loan scheme framed by them also. Up to 7.5 lakhs, there is no requirement of giving any collateral security.
And what is educational loan? Is it defined somewhere that it is different from other loans? Educational loan,
Yes, your lordship.
where is it?
This in the objective itself, it is stated, your lordship.
Hmm.
In the model education limb, I have also annexed in the writ petition, your lordship, and our own high court, your lordship, our own high court in a case was bound to direct the, it was in case of another bank, your lordship, Canara Bank. There they have taken a ground, like my friend has said, that you did not apply in the nearest bank. The court said that no, this is an artificial parameter which is not covered under the act. So the court said that it should not be treated as a precedent. But in exceptional circumstances, this court has also directed, your lordship, for granting education loan at that time to the Canara Bank, because at that time they denied on the ground that you should have approached the nearest bank. So she has approached the nearest bank in respect of Canara Bank. This was nearest, so she approached that bank. The court said that cannot be a ground to deny, and accordingly directed that she should be given the loan. Now, this is the case, your lordship. I am, first of all, as per their own model scheme, your lordship, they have not communicated the reason. Had it done them within 15 days, I would not have come before this honorable court. I have thought of otherwise. And secondly, your lordship, even in case of rejection, they must show that there was a concurrence from higher authority, and they have given me the reason that for this reason you are being denied. So at this stage, your lordship, I'm not in a position to approach any other bank, your lordship, and my future may also be jeopardized, your lordship. And I am otherwise eligible under this scheme. That is my case.
And what have you brought on record through the additional affidavit?
That other public sector banks like that of the petitioner, they are also public sector banks. They have already granted loan to similar courts, your lordship. At page 60, And at page 66, your lordship will see this one Canara Bank has given loan. And the Punjab National Bank, it is also a public sector undertaking, your lordship.
Your client is pursuing the course in Guwahati.
No, in same institute. In the same institute, same course, other student from those have applied, one from Canara Bank he has got, one from State Bank of India he has got. So it is ultimately this model education loan scheme is to be followed by all the public sector undertaking. Even the private sector banks are also required to follow it, because here the criteria is that a meritorious student should not be denied. And the only thing that they are required to see is the rate of employability criteria. After the course, whether he has a chance of getting employment, and this diploma in pharmacy, it has a very good probability of getting employment, your lordship. And otherwise, I'm eligible under this scheme because I have been admitted through a merit-based selection process. There are only cases that it is not a common entrance test. Had it been that there is a common entrance test, I did not participate, I somehow got an admission. There is no common entrance test for such type of courses throughout the state of Assam. Even throughout India also, there is not a common entrance test. Common entrance tests are for engineering course, medical course, IITs, IIMs, even for law also nowadays, there is a common entrance test called CLAT, but that is only for national law schools. But for other institutes, they conduct their own entrance test, your lordship. So had it been a case that no, there is a common entrance that I have bypassed it and I have got selection through some other process, that have been a case. This is a course where there is no common entrance test. Every institute conducts its own test, your lordship, and I have been appointed through a merit-based selection process. I have completed first year of the course also. I have passed first year with 58.5% marks, your lordship, and now I am
This
passing.
is after HS or HSLC?
HS. After HS.
After higher secondary.
Higher secondary.
But we have given the circular that has been framed by the bank. And our stand remains the same, that either it has to be a common entrance test, as I've said.
No,
If it
that's
is
right,
not-
but you have received this application.
Yes,
Yes, apply.
this is all online. Manoj.
What have you done with it? Have you informed him that it is
It
rejected?
appears to me that directly, Manoj, by in writing, he was not informed. Manoj. It was verbally informed to him. To that extent is right. But Manoj, if my learned friend is suggesting that because I did not inform, then there is a right to claim a loan, Manoj, that would not be correct. For that, Manoj, it is correct that he applied
But
online.
other nationalized banks appear to have extended.
No, it
loan-
appears to me that the SBI, Canara Bank, or any other bank, they all have individual policies with slight modifications, because the IBA, my friend is harping on the IBA, but IBA is a non-statutory forum. It's a forum of banks only. We are not bound by it absolutely. We do follow the model because it is supervised by the
No,
RBI.
You see, one issue here is you are saying that you can get educational loan with collateral security.
Yes.
These are
I'll-
oxymoronic.
I'll try to
This is an
distinguish.
oxymoron.
I'll try to
Because
distinguish.
with collateral security, anybody can get any loan.
Hello.
Education loan is not supposed to be on
Yes.
collateral
Well,
security.
here there are three categories of loans, mainly for those students who are otherwise meritorious but are not able to afford studying in a higher forum. Now, PNB Saraswati is basically for the institutes which are not premier institutes. For example, the IITs, IIMs, those are apart from those institutes, any general institute is covered by Saraswati. We have other schemes like the Uran scheme, which is for abroad, or the other scheme is their Pratibha. That is for select premier institutes like IITs or IIMs, wherever, or MBBS courses. So it is restricted in category wise. What we meant in paragraph to the reply in paragraph 10 was that he is not eligible under the Saraswati scheme, but he is otherwise eligible for the educational loan because we have a general education loan. For the other students, we can afford the loan. Afford the loan, when I say afford the loan, it means by collateral.
You say that because according to you, of course, there was no common entrance test. That
Logic.
goes.
Yes.
But why do you say it is not merit based?
Not merit-based selection process. What is happening is that suppose in a localized institute of this nature, Manoj, Lordship has seen at page 17, it is based on an interview, Manoj. There is no merit-based means, Manoj, his merit has to be examined as to how much marks he got in his.
Where is it written? Where does it lay down? That merit based will be this and not that.
To that extent, Manoj, it is not there. But
Is it not
merit-based.
completely abstract? According to you, all these do not make it merit based.
No, Manoj,
According
then-
to him, it makes merit
Then
based.
let us see what he has got. He has got 50% marks in the 12th, in the high secondary examination.
Hmm.
He has got admission to this institute on the basis of an interview, only of an interview.
Hmm.
What to talk of common interest, Manoj, there was not even a written test. It was only an interview. And that Lordship will see.
No, common entrance is not there.
It's not there. No, what to talk of a common interest, Manoj, there was not even an entrance test per se. Because there was only an interview, only a personal
No,
interview.
no, Mr. Ganguly, these are different matter. common entrance test was not there.
Not
Let's not go into that.
Yes. Now, if your lordship says merit.
Why is it that, is it that everybody who went got admitted? No, that's not the
No,
criteria.
that we cannot say, my lord, because we only have the list of who was appointed. Now, how
So
many
what you are
employees?
saying is you are not happy with the selection
So
process.
there are certain parameters because my lord, these are loans which my lord, have to be given examining certain parameters. Now he has got my lord, 50% in his class 12 examination. He has got admission to this institute on the basis of a personal interview only my lord. There was no written test at all. So, my lord, going by this, my lord, merit-based selection process doesn't mean that every candidate who gets appointed to an institute or gets admission to the institute will qualify, my lord.
Where have you clarified it?
Lordship?
Where is the clarification that these things will not be accepted as merit-based? There is no such clarification.
No, that point was not specifically taken, my lord, to be honest. And my lord, as far as the test part is concerned, my lord, we have said that
You have kept the thing very broad in your,
lordship, the affidavit.
you kept it very broad.
Yes, my lord, because initially the submission.
Merit-based is a very broad and vague term.
Yes, my lord.
Later on, you cannot develop.
We have not kept it, my lord. This we are following to this extent. We are following the IBA, my lord. Every bank says merit-based selection process or common entrance test. Here, my
No,
lord.
no, what I'm asking Mr. Ganguly,
Lordship.
merit-based is where you stop.
Yes.
Now, what would constitute a merit-based? That is not defined.
No,
anywhere.
merit-based, my lord, in my humble submission.
How is the court to hold that this is not merit-based?
No, lordship. Now, if I may clarify, my lord, I've spoken in detail to the bank regarding this. What happens is that, my lord, merit-based means, my lord, let us say that there is a selection process and he gets a certain rank or a certain position. Let us say, my lord, there are 50 candidates selected and he gets in the top 10 or 15 and then he gets admission where others are not getting. Here, my lords, from page 17, we do not know how many applied. We do not know how many got. We only know that these candidates were there. They got a certain marks in the interview and they have been given
So
admission.
without knowing it, how did you come to a conclusion that it was
No,
not
no,
merit-based?
it is not the burden for us to know. He has to upload the documents in the online process. He has to write to the bank, look, these are the documents. So, my lord, these are in financial these parameters are very difficult because otherwise it will open a floodgate. Every student getting admission will claim. That is the difficulty.
But then you come up with clear criteria that these type of courses or entrances or admissions.
No, courses we have no difficulty. As far as the course is recognized, there is no difficulty in that. But the point is that, my lord, the petitioner, but there is a point as to whether he can be called as meritorious. Now, meritorious is not defined. My lord. How do we ascertain? There are certain parameters, my lord, which we go by. We look at the process.
Get the appearance slip, please. Yeah. I'll go through the record and pass it on. Publish.
Item 2 for hearing.
Yes, good that. Yes,
In this case, my lord, ultimately admitted amount has been paid. So
admitted
far
amount has been paid.
So far, that amount is concerned, your lordship directed the tax department to submit a report and after due inquiry, they submitted the report. The dispute concern here concerning to the VAT amount. What my submission before your lordship can dispose of the matter because the admitted amount has been paid. That amount the authority submitted a report. Your lordship dispose of the petition, holding that the authority may proceed. If I am entitled or they are entitled the VAT amount for refund, they will get it.
So, let me just recapitulate. What is the facts?
Facts, my lord, we have been, I had been appointed to execute some works, my lord, by the respondent number 2 or by the respondent. Ultimately, I have completed the work and submitted my bill. Some bill unpaid, amount unpaid. Therefore, I approach this honorable court for winding up. And during they file an affidavit stating that out of 8 lakhs something, Out of 8 lakhs, I'm giving the details. 8 lakhs 92,161.25, my bill amount, they paid, they deducted 4,52,811.25 as that amount. Less than, according to them, my due was 3,02,959. During pendency of this company petition, they paid this 3,02,959 to me. I got it. Now only remaining is portion is 4,52,000, 4,39,350, the VAT amount. According to them, they deducted it from my bill.
Yes.
Now, at the dispute concerning to the VAT, your lordship directed the tax department and then submitted a report by filing an affidavit. On 29/8, probably 19. As your lordship got it.
Yes.
Affidavit filed by one Gautam Das, reported page 5 in the internal page.
Yes.
May I read it, my lord?
Yes, please.
Second paragraph.
Hmm.
I'll read it. Regarding deduction of tax by the respondent party, section 47 of the ABAT Act contain provision of tax deduction at source. The provisions of said section for deduction of tax at source is not applicable to any private limited company. Therefore, the respondent had no authority to deduct tax from the petitioner. The respondent in fact compounded his error by not depositing the deducted tax amounting to rupees 4,39,350 in the GOPS exchequer. We have scrutinized the return submitted by the respondent for the year 2008-9, 2009-10 and 10-11 to determine whether the respondent himself has deposited the tax due from the petitioner and therefore did not make over the payment on account of tax to the petitioner. However, this was not because of the audit report of 2009-10. This was not so because in the audit report of 2009-10 and 10-11, the turnover creditable to the petitioner for the said period were not incorporated and neither could be respondent give any evidence that he has added the turnover of the petitioner in his total turnover, which he has filed with the department in the form of annual return in Form 14 for the said period. In fact, the respondent was provided with the opportunity to submit a breakup of his total turnover as per annual return filed on 2008-9 to 2010-11, so as to enable us to determine whether work executed by the petitioner on behalf of the respondent is reflected in his turnover, that is respondent turnover, as a corollary whether tax due on his portion had accrued to revenue or not. The respondent, however, failed to do the needful, stating that the record of 2008-9 are missing, though he has submitted returns showing payment of the appropriate tax for the year 2009-10 and 2010-11. The fact, however, remains that there is nothing on record to prove that the tax due on the work executed by the petitioner has been realized. The respondent also could not submit any satisfactory evidence by way of Salan that tax on the work contract executed by the petitioner has been deposited. Prima facie, the respondent has deducted the tax from the petitioner, though being not eligible to do so, has not deposited the same to the government. It is also a fact that petitioner has failed to obtain
Yes.
Now the respondent hearing, they want to say that, no, we have not deducted that amount. And how they said, I don't know, but if you look to go through their affidavit, they himself admitted that we have deducted. That if they file an affidavit on 6/5/14, 6/5/14, page 4, has your lordship got it?
Yes, please.
6/5/14, their first affidavit, page 3, your lordship kindly take it out.
Yes.
Paragraph 12. That the deponent begs to state that as per agreement that an amount of ₹1 only remain outstanding for payment, out of which the petitioner received so and so amount. An amount of ₹4,93,550 is deducted from his account on account of this deponent. Next paragraph, your lordship, kindly have a look, paragraph 13. Paragraph 13, clause 5, clause 4. Has your lordship got it?
Yes.
Amount deducted on account of VAT from petitioner 439. This was not the one affidavit below. They also filed another affidavit
Yes.
on March 2015, my lord. If you look at March 2015, they filed an affidavit. Has your lordship got
There
it?
is an additional affidavit in opposition.
No, affidavit in reply filed on behalf of respondent against the affidavit that is even filed with the petitioner company on March, my lord.
So I have one filed on 5th September 2014.
No, thereafter, on March, in March 2015, thereafter, my lord, 2015, my lord.
There is one filed on 17th of March 2015.
Yes, my lord,
That is-
17th of March.
That is filed by the petitioner.
No, my lord, thereafter. Thereafter, next affidavit, my lord. Thereafter, they file out. In reply to my affidavit.
Yes,
You got it?
yes, yes.
My lord, page 5, your lordship, kindly look at me.
Yes.
Paragraph 6, my lord. Clause 4, my lord. Balance due as on date inclusive VAT 899, 892, 16125. Less VAT, VAT amount even 439, deduct 452. This is what 302 they paid to us. They deducted the amount. As per their affidavit, I have not said those. Their affidavit says they deducted the amount 4,39,350 as VAT. Therefore,
Yes.
what I submit before, and I cannot go beyond this would. So for admitted amount, I got it. So for VAT amount, authority will proceed me, Lord. If I am entitled to get the refund, I'll get it. Authority submitted report. And they can proceed with the as per the report below. That's my humble submission.
What is the prayer in the company petition?
I wind up. There is nothing to be wind up. It
So
can be
you are not pursuing the winding up.
I am not pursuing the wind up. I got the amount, but for the amount of VAT, If I am entitled to get it from the government, I will get it, my lord. That VAT amount is, they create the dispute.
Yes, Mr. Datta, your client seems to be taking a very dubious stand in this matter.
Maybe.
On one hand, you say that you have deducted VAT.
No, Lordship,
Then you did not-
maybe some using of word from the ignorance of the council from our side. But fact remain is that, Lordship, for my satisfaction, Lordship, kindly have a look of the bill submitted by that petitioner to us, Lordship.
No.
I am clarifying, Lordship.
Just a minute, just a minute. Let us take it that you have bona fide deducted the VAT from his bill.
Lordship,
Let us take it.
Lordship,
You have to deposit it with the authority.
Lordship.
You can't appropriate that amount.
Lordship, I am just for that, Lordship, for my satisfaction, Lordship, kindly have a look the bill.
Hmm.
Lordship, this is the bill, Lordship, submitted by petitioner to us, Lordship. Lordship, in the below, Lordship would print that VAT amount. In the bill, he added a VAT amount, Lordship. Lordship got it?
Hmm.
Just below,
Yes, yes.
Lordship,
12.5%.
12.5%, Lordship. He submitted total bill of 54 lakh something, Lordship,
Hmm.
inclusive that VAT component, Lordship.
Hmm.
And if Lordship go to the affidavit, additional affidavit in reply filed by the petitioner himself on Lordship 14/7/14, Lordship, he has annexed his VAT registration certificate. The VAT registration certificate which he submitted to us, Lordship, is on 19 November 2010, Lordship. Till 19 November 2010, Lordship, he has no VAT registration number, Lordship. That is why the amount claimed by him, Lordship, in that bill, Lordship, he is not entitled. He is entitled to the other bill, Lordship, but the VAT amount he is not entitled. If, Lordship, I paid that amount to him,
He
I
is
will-
not entitled to your right,
Lordship,
but will you appropriate the VAT?
No,
That
Lordship,
is the tax.
no, Lordship, I am just telling you,
Hmm.
if he is an unregistered dealer, he cannot claim VAT in his bill, Lordship. And if I pay that
No,
bill,
Mr. Datta, I'm not interested to hear all these arguments.
uh,
The fact of the matter is, your client will have to pay interest on the amount at the rate of 9% from the date on which it
no,
was deducted till payment. If it is found that after deducting the amount, he has not deposited it
no,
before the
Lordship,
authority.
deducting, when I shall deduct, Lordship. If he is entitled, then if I deduct, then I will be liable to pay, Lordship.
You
if
have
he is not
admitted
entitled-
that you have deducted
No,
from that
Lordship.
39,000.
Kindly annex
No,
affidavit.
Mr. Datta, I have no time for all these arguments.
Yes, Lordship.
You are playing hide and seek with the.
No, Lordship, sorry, Lordship.
You have deducted the amount.
Lordship deducted.
You have deducted as per your own
I have
pleading.
not paid, Lordship.
Huh?
It is not deducted, it is, I have not paid him.
Correct.
Yes.
So that is the VAT component according
VAT
to you.
common if he is entitled, Lordship. If he is not entitled, then if I
But you
pay,
have kept
Lordship.
it to yourself.
No, if he is not entitled, if I pay, I will not get the impost, Lordship, input return, Lordship.
All right.
It is my contention, Lordship. If Lordship kindly,
I would have understood everything that you thought VAT is applicable, you deducted very well. That
VAT
can
is not
happen.
applicable to him,
But
this is
you
my
have
contention.
deposited with the
No,
authority.
Lordship, it is not, Lordship, this is just not system, Lordship, if I, my understanding of VAT, Lordship.
Hmm.
Suppose, Lordship, he raised a bill of 100 rupees, Lordship,
Hmm.
and he added another 10 rupees of VAT. I will have to pay 110 rupees, Lordship.
Hmm.
That 10 rupees VAT component, I will get refund from the authority if he is a registered dealer.
Hmm.
If he is not a registered dealer, that 10 rupees I paid to him to extra, it is his illegal entitlement, Lordship. I will not get back from the department, Lordship. So he is not entitled, so hey, that 10%, 10 rupees, I have not paid him, Lordship.
All right, we'll clarify that if the amount is if appropriated illegally,
Lordship.
then your client will be liable to pay.
Yes,
interest.
Lordship. Yes, that is, I have no problem. And I have detail in my affidavit 23rd May 2015. What amount is due to him, Lordship, and what is not, Lordship. And he has read, Lordship, the very first part of the inquiry report, not the first paragraph, Lordship, which is goes against him. And again, their inquiry report, Lordship, I have filed affidavit in reply also, Lordship. Lordship, my one another submission, Lordship permit.
Yes,
Lordship, there is a arbitration clause also.
yes.
And if any amount, Lordship, is disputed, that as per Lordship, Supreme Court settled position of law, and Lordship has also filed that any disputed question is not to be raised before the winding up proceeding, Lordship. Lordship, I may rely on that judgment, Lordship, which is fully cover my case. Lordship can delegate the party for arbitration if any party is entitled.
All right, take down heard Mr. S. Kotogi, learned counsel appearing for the petitioner, also heard Mr. P.B. Datta, learned counsel appearing for the respondent. This petition has been filed under section 433, read with section 434 and 439 of the Companies Act 1956, praying for an order for winding up the respondent company on account of the fact that the respondent is unable to pay its debt. Full stop. The facts of the case, in a nutshell, are that the petitioner herein is engaged in the business of supply of guide mast, G-U-Y-E-D. Is the spelling correct? Guide mast?
Yes.
Spelling is correct. G-U-Y-E-D mast, along with accessories, and also for providing manpower for system integration and installation and commissioning of telecommunication equipments. See it from para 1. The respondent company had issued a purchase order dated 01/08/2008 in favor of the petitioner for supply of certain materials. Full stop. Upon receipt of the purchase order, the petitioner had executed the purchase order dated 01/08/2008 and supplied the entire amount to the supplied the entire and completed the entire supply to the fullest satisfaction of the respondent. Whereafter, bill for a total amount of rupees 54,65,721 was raised, which was also duly received by the respondent company. Full stop. After receiving the bill, the respondent had made payment of an amount of rupees 32,16,700. It is 32,16,700. Thus, leaving a balance amount of rupees 22,49,021 as due to the petitioner. Full stop. When the respondent company neglected to pay the aforesaid amount, despite repeated requests made by the petitioner, a situation had arisen when the petitioner had aggressively pursued its claim. Full stop. At that stage, an agreement dated 22/3/2011 was entered by and between the parties, whereby the respondent agreed to pay a sum of rupees 17,79,672 to the petitioner out of the balance amount of 22,49,021 after deducting a sum of rupees 4,39,350 on account of VAT. Full stop. Thereafter, the respondent had paid a sum of rupees 8,50,000 to the petitioner after deduction of VAT. Full stop. Notwithstanding the same, the balance amount of rupees 8,94,269 was lying unpaid by the respondent company. Since the respondent had failed to pay the aforesaid dues, the petitioner was compelled to approach this court by filing the instant petition seeking winding up of the company. Full stop. During the pendency of this proceeding, this court had passed order dated what is the date of the order calling for report?
Lordship 1719.
Passed order dated 7/3/2019. No, before that you write. From the pleadings brought on record, it was evident that the core dispute between the parties was pertaining to the sum of rupees 4,39,350, which the respondent seeks to deduct from the unpaid dues of the petitioner on the ground that the same was the VAT component. Full stop. Taking note of the contentious issues involved in this petition, this court had passed order dated 7/3/2019, requiring the sales tax department to examine the issue and submit a report. Accordingly, the Superintendent of Taxes, Unit C, Guwahati, had carried out an inquiry in the matter and submitted a report dated 10/4/2019 addressed to the Commissioner of Taxes, Assam, Kor Bhavan, which was brought on record by the said by the Joint Commissioner of Taxes by filing affidavit dated 29/8/2019. A perusal of the report prima facie indicates that the VAT component was not applicable in case of a private limited company such as the petitioner, is it?
And he is
And
an unregistered dealer.
Huh?
And he is an unregistered dealer. It is written, Lordship, first paragraph.
Who was an unregistered dealer, and therefore the question of deducting the amount of rupees 4,39,350 from the bills of the petitioner did not arise. Full stop. Be that as it may. Today, when the matter was called up for final hearing, Mr. Potaki, learned counsel for the petitioner, submits that during the pendency of the writ petition, the admitted dues of rupees 3,02,959.25 has been paid to his client, and therefore the only dispute which now arises for adjudication is as to whether the respondent was justified in deducting the sum of rupees 4,39,350 as VAT component. Mr. Koteke submits that in view of the stand taken by the sales tax department that no such amount was deposited by the respondent in the government exchequer, the matter would have to be pursued at the departmental level by reserving the right of the petitioner to seek refund of the amount if deducted illegally. Full stop. Responding to the above, Mr. Datta, learned counsel for the respondent, submits that no order for winding up of a company can be issued when can be passed when there are disputed questions of facts relating to the claim and counterclaim of the parties. Full stop. Since the agreement dated date of the agreement, since the agreement dated
22nd March 2020.
22/3/2011 entered by and between the parties contains an arbitration agreement. Therefore, the dispute now surviving in this matter is required to be resolved by referring the issue to the arbitration, to arbitration. First up. Mr. Kotoki has also fairly submitted that in view of the subsequent developments, he has instructions not to pursue the prayer for winding up the respondent company. However, according to the learned counsel for the petitioner, liberty be granted to the petitioner to pursue all legal remedy as may be permissible under the law for realization of its dues under the contract. Full stop. Taking note of the submission made at the bar, this company petition stands disposed of by granting leave to the petitioner to pursue appropriate remedy, including arbitration proceeding as well as application before the Sales Tax Department, Assam, for enforcement of its claim. Full stop. Claim in accordance with law. Company petition stands closed.
Apply.
Three.
Well, before starting my friends, my lord, I have one problem, my lord. The Hatko, my lord, I find my lord Ugalat now I sign up on behalf of Mr. Mano B. Kulita. Senior Bigman, he's a penalty to it, my lord. He already might have expired, my lord. My lord, unless my lord,
No, but we'll not adjourn 2000.
unless my lord Hatko has not, my lord, authorized me to appear, my lord, I cannot appear, my lord, in this case.
Let us see what is the matter.
Yeah, please, your lordship.
Lordship, the matter is regarding non-issuance of the no due certificate by the HUDCO, Lordship. Here, the husband of the petitioner took a loan of 1,40,500, 1,46,500 from the respondent number 3 society. Respondent number 3 society. And the said amount was sanctioned to the respondent number 3 by HUDCO. The principal amount was given by HUDCO to the society, and society given a loan to the petitioner. It's a housing society of 1,46,500, Lordship. There is a agreement between the petitioner and the society. That amount will be given by the society to the petitioner, and they will pay to the society, and society will subsequently pay it to the HUDCO. So in the year 1994, Lordship, at page 1, Lordship, the petitioner requested the society to let him know about the outstanding about his dues regarding the loan amount. And on 28/10/1994, Lordship, the society informed that petitioner husband that 40,195 rupees is pending in his account, Lordship. And the loan statement was given at page 17, Lordship. Page 17 is the statement of the loan. At the top, KK Kolita, husband of the petitioner, SB Housing Society, loan amount 1,46,500. And at the bottom, Lordship, as on 30/11/1994, the loan amount was 40,195. The husband of the petitioner paid that amount, Lordship, by way of a check, Lordship, to the society. The
So
society.
this dispute is between the petitioner and the respondent number 3.
Respondent number 3, the respondent number 3 has not disputed. Respondent number 3 issued the NOC also, Lordship, which is at page 21. It is to certify that Mr. Krishnakanta Kolita, owner of so and so of Santigram Housing Complex Society, has today on 28 October 1994 made the full and final payment of his outstanding HUDCO loan amount to the society. So this may be treated as clearance certificate of his loan liabilities to the society. So this payment regarding the payment, Lordship, the society duly informed to the HUDCO, and the petitioner also informed the same to the HUDCO. Then the HUDCO written a letter, page 22. Page 22, HUDCO written a letter to the society, secretary of the society, in which it is written that, page 22, Lordship, a copy of the letter in respect of the full repayment of the repayment of HUDCO loan received on 23/5/1995 from KK Kolita is enclosed herewith for your information. In that connection, I would like to request you to furnish the following information for further processing the case. Number one, to confirm the scheme number in which KK Kolita was allotted flats, to confirm the loan amount sanctioned to KK Kolita, and the date of his final repayment, relation of the check. You are requested to furnish the similar information and confirmation in respect of beneficiary members who have already cleared HUDCO loan through your society to endeavor for further processing of the case, Lordship. Then the society, Lordship, informed the same to the HUDCO on which is at page 26, Lordship. There are some other communication also there. Society was not responding, therefore the petitioner also write some letter. Page 26, Lordship, the society intimated the HUDCO official, Lordship. It is in reference to your letter dated 12/6/1995. We are hereby confirm the following. Loan availed by KK Kolita under scheme 60191. Total loan amount 1,46,500. Date of final payment 28/10/1994. Realization of the check on 3/11/1994. And this letter was duly received by the HUDCO. The dear seal and signature is also there.
Final payment by whom?
Final payment by the husband of the petitioner to the society. And society is supposed to pay the same to the HUDCO. So thereafter, Lordship, NOC was not issued to the petitioner's husband. Then the society again wrote a letter, which is at page 28, giving all the details. May I read the page 28 last portion? Page 28 last portion. We therefore write to you that we have no objection for issuing no due certificate to Kolita from your end at the most. But they did not do anything. Then on the petitioner again requested them to issue the letters and all. And on page 29, Lordship, the HUDCO officials issued me a letter. In this letter, it is written that with reference to your letter dated 19/7/1995, I am directed to inform you that the copy of no demand certificate issued by SB Housing Cooperative Society Limited, submitted by you along with your letter, is seen and recorded. It was issued by the HUDCO officials. Then, Lordship, what happened, Lordship? The society failed to pay some amount to HUDCO. Then HUDCO went to DRT proceedings and they filed 2 applications before the DRT proceeding. In the DRT proceeding, Lordship, the society and the chairman and the secretary was made a party, and the register of the cooperative society was made a pro forma respondent. At page 30, it can be seen, Lordship. The flat owners, the beneficiaries, were not made parties in the said proceeding, Lordship.
What has happened to the proceeding?
Lordship, that way were allowed, Lordship. The way were allowed, Lordship, and with some conditions, Lordship. May I read those conditions?
And what does the respondent number 1 and 2 say in the affidavit?
Respondent number, the respondent, the society did not that before the DRT,
No, here.
here they have filed their affidavit, Lordship.
What is the statement?
In the affidavit, they have admitted those facts, Lordship, that the loan amount, the loan was sanctioned to the society, that then the joint liability to the society. May I read paragraph 5, Lordship,
Yes,
at page 2 of the affidavit.
yes.
With regard to the statements made in paragraph 3 of the petition, the deponent states that the loan in question was sanctioned by the respondent number 2 to the SB Cooperative Society, that is respondent number 3. Some of the flat owners, including the present petitioner, had availed the loan facility through the society as the beneficiary of the loan. And in that way, the society and the beneficiaries become jointly liable to make repayment of the loan amount. As per the arrangement made between the parties, the beneficiaries were required to make payment of the installment for repayment through the society. And the society paid the said amount to the respondent number 2. And on completion of the repayment in full, the society is required to intimate the same to the respondent number 2 and to move for issuance of no due certificate. And the respondent number 2, on receipt of requisition from the society, used to do so. So they admitted these facts. And in our case, Lordship, the husband of the petitioner completed all those process. He paid the amount to the society. It was duly intimated to the HUDCO. HUDCO wrote a letter to them.
So we'll clarify, there will be no personal liability, whether the no dues is given or not. Your client will have no personal liability,
Lordship.
in this matter.
Lordship. In
Yes.
fact, the DRT also said that those persons who have paid their dues,
Where is that finding?
that finding is at page 35. Page 35. Page 35, paragraph 12 is important. In view of the matter, both applications are allowed contest against the defendant number 1, 2, and 3. No claim has been made against defendant number 4. Similarly, no decree can be passed against the beneficiaries since they are not direct parties to the transaction of the loan. And the last portion of paragraph 13, I'm reading from the last 4 lines, Lordship. The applicant is allowed to invoke the mortgage for recovery of the amount due. But on that event, it has to be taken note by the applicant that the flats in respect of which the applicant already issued no due certificate should be excluded from the purview of invocation. So those who have paid their dues to the bank, to the society, they should be excluded, Lordship. But in this case, the HUDCO authority did not issue the no due certificate. So now as per my instruction, Lordship, till date, the society has not paid the loan. And HUDCO also sitting over the matter. So
No, in any case, whether the HUDCO issues no dues or not,
Lordship,
we'll clarify that there is no personal liability.
Lordship,
Since this certificate, you have taken the loan from the society.
Society,
Society has given you no dues.
no dues.
That's final.
Lordship.
Whether HUDCO issues any further certificate or not,
And they have seen and recorded in their record also.
yes. You are for 1 and 2.
But HUDCO, madam.
I am asking you are for respondent numbers.
1 and 2.
Then why did you say no? You are for 1 and 2.
1 and 2.
Say that. Say yes. Say yes. Don't be so casual.
Madam, I have some difficulties because, madam,
Either you appear or you don't appear.
I'm not appeared, madam.
Okay.
Because
Take down heard Mr. D. Chaudhary, learned counsel appearing for the petitioner. None has appeared for the respondents. Also, although the name of the learned counsel is duly reflected in the cause list. Full stop. The petitioner.
reasons for non-appearance may be recorded, otherwise it will have.
No, you can't appear and
But-
not appear at the same time.
And reasons may maybe.
Then you say that you appear, but you don't have any instruction.
Madam.
Then you write, Mr. A. Kanikar, learned counsel has appeared on behalf of the respondent numbers 1 and 2 and submits that since the brief was entrusted to his senior,
We call it, madam.
Mr. B. Kalita, your senior
Madam. At that point of time, madam.
at that point of time, he does not have any instruction to make any submission in the matter. Full stop. Mr. or late B. Kalita, is it?
Madam,
Late B. Kalita. That is his senior.
I have informed, madam, HUDCO, madam, that they have not responded, madam.
And since the HUDCO has not responded to the information furnished by him seeking instruction, he does not have any submission to make in the matter. Full stop. take down. The writ petitioner herein is the widow of late Krishna Kanta Palita, who had availed a loan amount of rupees 1,46,500 from the respondent number 3 society for purchase of a flat. Full stop. Late K.K. Palita was a shareholder in the respondent number 3 housing society and therefore had availed financial assistance from the respondent number 3 to the extent indicated above for purchasing a flat. Full stop. The respondent number 3 had obtained financial loan from the respondent number 2 for onward disbursement to its shareholders for the purpose of purchase of flats, residential flats for the members of the society. Full stop. The grievance of the petitioner is that although her husband had repaid the entire loan amount with interest way back in the year 1995, and the said fact and the no dues certificate was also issued by the respondent number 3 in favor of her husband, her deceased husband, on 28/10/1994. The respondent numbers 1 and 2 are yet to issue no dues certificate to her, although the aforesaid fact has been duly intimated to the said authorities. Full stop. In support of the contentions made in the writ petition, Mr. Chaudhary, learned counsel for the petitioner, has invited the attention of this court to the no dues certificate issued by the respondent number 3 in favor of the deceased husband of the petitioner on 28/10/1994, wherein it has been categorically mentioned that late Krishna Kanta Kalita had made full and final payment of his outstanding HUDCO loan amount to the society. Full stop. The aforesaid fact was also intimated. The receipt of the said information was acknowledged by the assistant finance officer of HUDCO, is it? By the letter dated 12/6/1995, addressed to the secretary of the respondent number 3. Wherein certain additional information regarding the scheme number under which the flat was allotted to K.K. Kalita and the loan amount sanctioned to him, including the date of final repayment. Full stop. On receipt of the aforesaid communication dated 12/6/1995, the secretary of the respondent number 3 society had furnished the requisite information on 25/7/1995, wherein it has been categorically mentioned that the sum of rupees 1,46,500, including the balance dues of rupees 40,195, was realized from the shareholder, namely K.K. Kalita, by check dated 3/11/1994. The secretary of the respondent number 3 had also issued a separate communication dated 26/7/1995, addressed to the respondent number 2, addressed to the regional chief of the respondent number 2, intimating that the respondent number 3 would have no objection if no due certificate is issued to Sri K.K. Kalita from their end. Notwithstanding the same, and despite having received all the communications from the respondent number 3, no action was taken by the respondent number 1 and 2 to issue the no due certificate to the petitioner or her deceased husband. Under the circumstances, the writ petitioner seeks a writ of mandamus directing the respondents to do the needful. Full stop. It appears from the materials on record that there was that some of the shareholders of the respondent number 3 society had defaulted in repayment of the loan, as a result of which the respondent number 2 had instituted a proceeding numbered and registered as OA number 182/97 and 183/97, not instituted proceedings bearing number so and so and so and so before the Debt Recovery Tribunal, Guwahati at Ulubari, praying for a certificate of recovery against the respondent number 3 and its chairman and secretary. Full stop. By the judgment dated 8/5/2003, the aforesaid original applications were allowed, whereby a certificate of recovery was issued in connection with OA number 182/97. 183 is not required, only write 182/97. A certificate of recovery for an amount of rupees 1,40,14,309 was issued to be jointly recovered from all the 3 defendants. Full stop. In the aforesaid order, it was however clarified that the certificate of recovery would exclude those flat owners in respect of whom the housing society had already issued no dues certificate. Full stop. Next paragraph. By filing a joint counter affidavit, the respondent numbers 1 and 2 have also admitted that the respondent number 3 had recommended for issuance of no dues certificate in favor of the deceased husband of the petitioner. However, since the husband of the petitioner had not made direct repayment of loan to the HUDCO, no dues certificate could not be issued. Full stop. If the logic furnished by the respondent numbers 1 and 2 is to be accepted, then what is apparent is that the husband of the petitioner had also not availed any loan directly from the respondent numbers 1 and 2. And to that extent, the said respondents cannot have any claim against the petitioner or her deceased husband pertaining to the loan account or the flat under her occupation. Full stop. If that be so, and considering the fact that the respondent number 3 society has already issued no dues certificate to the petitioner and intimated the matter before the respondent numbers 1 and 2, there can be no further liability on the part of the petitioner pertaining to the loan availed by her husband. Full stop. In other words, regardless of whether no due certificate is issued by the respondent numbers 1 and 2, in view of the certificate issued by the respondent number 3, and considering the stand taken by the respondent numbers 1 and 2 to the effect that the repayment was not directly made to the said respondents by the petitioner, the question of respondent numbers 1 and 2 having any future claim against the petitioner in respect of the loan amount of rupees 1,46,500 would not arise in the eye of law. Full stop. This said position stands further fortified in view of the specific observations made by the learned DAT in the judgment and order dated 8/5/2003, passed in OA number 182 of 1997. As such, this writ petition stands disposed of by clarifying that the respondent numbers 1 and 2 cannot, having taken this, respondent numbers 1 and 2, having taken the aforesaid stand against the petitioner in their counter affidavit, cannot have any future claims against the petitioner, nor would there be any future claim against the petitioners for the aforesaid loan amount, nor can the respondent number 3 have any such claim. As such, regardless of whether no due certificate is issued by the issued by the respondent numbers 1 and 2, the petitioner shall stand fully discharged from any liability under the loan availed from the respondent number 3. As noted above, the writ petition stands closed. Yes. Yes, what is the next matter?
Five.
Give me.
May I please, your lordship?
Yes. What is my, you made a mention in this case?
Yes, your lordship.
Why?
I have stomach problem, your lordship. That's the only reason, your lordship. Maybe 2-3 days, any date, your lord.
No problem. She took my consent in the morning, Lordship. I
All right.
said yes.
Ms. P. Das, learned counsel appearing for the petitioner submits that he is suffering from some physical discomfort today, as a result of which is unable to conduct a hearing of this case. As such, a request has been made post this matter after 2 weeks. Ms. R.D. Mojumdar, learned counsel is present for the respondent and does not have any objection if the prayer is allowed. Although this is an old matter pertaining to the year 2014, yet having regard to the ground on which the prayer for adjournment has been made, which is personal difficulty faced by the petitioner's counsel, I am inclined to allow the prayer. Register to list this matter for hearing again after the upcoming puja vacation. Yes.
Highly obliged, Lordship.
Deeply obliged, your lordship.
Regarding item 7, prior to arguing here, nowadays, that this custodial debt matters are possibly taken up by the division bench. So I wanted to make it clear. Otherwise, we are ready, my lord.
You check it out and let me.
Yes, my lord, that's fine.